On February 23, 2013, at about 12 p.m. near the location of 63rd and Kelly, defendant was stopped by Sheriff Marshall, a law enforcement officer, for not wearing a seatbelt, and was written a citation for failure to wear seatbelt, in violation of 47 OS. 12417. A. The officer seized the evidence in violation of defendant's Fourth Amendment rights as his reasoning for seizure is fatally defective in establishing probable cause. The officer was without any probable cause to stop defendant. Defendant has the right to not wear a seatbelt because of a disability, and he has the right to not be discriminated against because of his disability. All evidence obtained as a result of this illegal stop must be suppressed as a matter of law. This is based upon defendant's right to be free from unreasonable search and seizures under the United States Constitution, Amendments 4 and 14, and the Constitution of the State of Oklahoma, Art 2, Section 30. It is also based on defendant's right to be free from discrimination under the Americans with Disabilities Act of 1990, Title II, Sec. 202, 42 U.S.C. 12132 and Section 504 of the Rehabilitation Act. It is a violation of the Oklahoma law to drive a car without a license. It is not a crime to drive a car with a proper license. It is the law of the land as spelled out by the Supreme Court that, even though it may be an offense to drive a car without a license, an officer cannot stop someone they see driving a car just to see if they are properly licensed. It is a violation of Oklahoma law to drive or ride in the front seat of an automobile without wearing a seatbelt without a proper license restriction on your driver's license. It is not a crime to drive or ride in a car without a seatbelt on if you have a restriction on your license that gives you that right to do so. Based on Supreme Court rulings, an officer cannot stop someone they see driving or riding without a seatbelt on to see if they are properly licensed to do so. Oklahoma law stipulates that a person may receive permission from the Commissioner of Public Safety in the form of a restriction added to one's driver's license which allows that person to drive a motor vehicle without wearing a seatbelt. The Commissioner of Public Safety, upon application from a person who, for medical reasons, is unable to wear a safety belt system supported by written attestation of such fact from a physician licensed pursuant to Section 495 of Title 49 of the Oklahoma statutes, may issue to the person an exemption from the provisions of this section. The exemption shall be in the form of a restriction appearing on the driver license of the person and shall remain in effect until the expiration date of the driver license. Oklahoma State Statutes, Title 47, Chapter 12, Article 4, Section 417. Defendant has suffered for years with a medical condition that makes it impractical for him to wear a seatbelt and has obtained a license to drive without a seatbelt. The officer did not know prior to the stop if defendant had in his possession a license to drive without a seatbelt or not. He was therefore without the required information to even create a suspicion of a violation of the law. The officer had to pull over defendant to find out if the crime was being committed by looking at his license. However, defendant has such a license. No crime was being committed, and since the officer cannot know this until after the stop must be deemed unreasonable. Since the officer was unable to know if a crime was being committed in his presence prior to stopping defendant, the officer did not have probable cause for stopping defendant. The stop was merely a random stop of someone whose papers may or may not be in proper order. Reasonable suspicion is also further lacking as defendant's behavior was innocent activity since he has a license to drive without a seatbelt. The principle that there is a presumption of innocence in favor of the accused is the undoubted law, axiomatic and elementary, and its enforcement lies at the foundation of the administration of our criminal law, beginning with the officer on the street. Reasonable suspicion is also further lacking as defendant's behavior was innocent activity since he has a license to drive without a seatbelt. The principle that there is a presumption of innocence in favor of the accused is the undoubted law, axiomatic and elementary, and its enforcement lies at the foundation of the administration of our criminal law, beginning with the officer on the street. Defendant has a constitutionally protected right to be secure in his person, papers, and things, and to be able to expect his privacy not be invaded at the whim of law enforcement. In Delaware v. Prowse, In 1979, the Supreme Court made it perfectly clear that a stop made where the violation is dependent on one's papers and at one for a clear violation of some traffic law is expressly prohibited. The Supreme Court stated the foremost method of enforcing traffic and vehicle safety regulations, it must be recalled, is acting upon observed violations. Vehicle stops for traffic violations occur countless times each day, and on these occasions, licenses and registration papers are subject to inspection and drivers without them will be ascertained. To insist neither upon an appropriate factual basis for suspicion directed at a particular automobile nor upon some other substantial and objective standard or rule to govern the exercise of discretion would invite intrusions upon constitutionally guaranteed rights based on nothing more substantial than inarticulate hunches. Terry v. Ohio. By hypothesis, stopping apparently safe drivers is necessary only because the danger presented by some drivers is not observable at the time of the stop. When there is not probable cause to believe that a driver is violating any one of the multitude of applicable traffic and equipment regulations, or other articulable basis amounting to reasonable suspicion that the driver is unlicensed or his vehicle unregistered, we cannot conceive of any legitimate basis upon which a patrolman could decide that stopping a particular driver for a spot check would be more productive than stopping any other driver. This kind of standardless and unconstrained discretion is the evil the court has discerned when in previous cases it has insisted that the discretion of the official in the field be circumscribed, at least to some extent. The officer had no reason to believe that defendant did not hold a license that allowed him to drive without a seatbelt. Thus the officer had no factual basis to believe that he was violating any law. Stopping defendant amounted to nothing more than a spot check, as the officer did not know if defendant's papers were in proper order and stopped him on nothing more than an inarticulate hunch that he would not have the appropriate papers. As in Delaware v. Prowse, the officer stopped defendant without any viable suspicion of unlawful activity in order to check his driver's license and insurance verification. Defendant's right to privacy must be protected as stated by the Supreme Court in Delaware v. Prowse. The grave danger of abuse of discretion cannot disappear simply because the automobile is subject to state regulation, resulting in numerous instances of police-citizen contact. KDV. Dombrowski, 1973. Only last term we pointed out that if the government intrudes, the privacy interest suffers whether the government's motivation is to investigate violations of criminal laws or breaches of other statutory or regulatory standards. Marshall v. Barlows, Incorporated. There are certain relatively unique circumstances in which consent to regulatory restrictions is presumptively concurrent with participation in the regulated enterprise. Otherwise, regulatory inspections unaccompanied by any quantum of individualized, articulable suspicion must be undertaken pursuant to previously specified neutral criteria. An individual operating or traveling in an automobile does not lose all reasonable expectation of privacy simply because the automobile and its use are subject to government regulation. Automobile travel is a basic, pervasive, and often necessary mode of transportation to and from one's home, workplace, and leisure activities. Many people spend more hours each day traveling in cars than walking on the streets. Undoubtedly, many find a greater sense of security and privacy in traveling in an automobile than they do in exposing themselves by pedestrian or other modes of travel. Were the individual subject to unfettered governmental intrusion every time he entered an automobile, the security guaranteed by the Fourth Amendment would be seriously circumscribed. As Terry v. Ohio recognized, people are not shorn of all Fourth Amendment protection when they step from their homes onto the public sidewalks, nor are they shorn of those interests when they step from the sidewalks into their automobiles. The decision in Delaware v. Prowse prohibits stops that require the officer to view a person's private papers in order to determine if the suspect has actually violated the law or not. Without a clear violation of a traffic law such as speeding, illegal turn, or failure to stop at a stop sign, the officer was without proper cause to stop defendant. If, however, the officer first sees a clear violation of the law and makes an appropriate stop, He can then properly ascertain whether or not the seatbelt law has been violated or not by checking the restrictions on the driver's license. Defendant holds a license to drive without a seatbelt. Officers do not know that he is not committing a crime when he is not wearing a seatbelt. He should not be subjected to countless stops because he is disabled. He and others with medical conditions that obtain exemptions from the Commissioner of Public Safety should not be continually stopped and harassed by officers that think they are violating the law. Stops, as in this case, where the officer has no reason to believe that the driver does not have proper license to not wear a seatbelt, and does not observe any violation of the law, as in the instant case, are unreasonable under the Fourth Amendment as stated by the Supreme Court. Accordingly, we hold that except in those situations in which there is at least articulable and reasonable suspicion that a motorist is unlicensed or that an automobile is not registered, or that either the vehicle or an occupant is otherwise subject to seizure for violation of law, stopping an automobile and detaining the driver in order to check his driver's license and the registration of the automobile are unreasonable under the Fourth Amendment. Delaware v. Prowse. The officer violated the Americans with Disabilities Act of Section 504 of the Rehabilitation Act by discriminating against defendant because of his disability. Title II of the Americans with Disabilities Act of 1990 prohibits disability discrimination by all public entities at local and state levels. It is unlawful to treat someone less favorably on the grounds of a disability. Under the Americans with Disabilities Act, no individual may be discriminated against on the basis of disability. The officer stopped defendant because he was not wearing a seatbelt. Defendant was not wearing a seatbelt because of his disability. He was therefore discriminated against because of his disability. The officer's conduct was unwanted and had the effect of violating defendant's dignity, created an intimidating, hostile, degrading, humiliating and offensive environment. Defendant was discriminated against by being denied full and equal enjoyment of driving on the streets. The remedy to stop the discrimination and harassment is to make one reasonable modification to the policy, which is to not stop people for not wearing seat belts. This modification will not fundamentally alter the nature of the privilege, nor will it result in an undue burden. The removal of this barrier is readily achievable. According to the Americans with Disabilities Act of 1990, for the reasons listed before, the policy must be changed. On signing the measure, George H.W. Bush said, "I know there may have been concerns that the ADA may be too vague or too costly, or may lead endlessly to litigation. But I want to reassure you right now that my administration and the United States Congress have carefully crafted this act. We've all been determined to ensure that it gives flexibility, particularly in terms of the timetable of implementation. And we've been committed to containing the costs that may be incurred. Let the shameful wall of exclusion finally come tumbling down." There is no reason to think that Congress intended to limit the availability of prospective relief against states who continue to discriminate against the disabled. Section 504 of the Rehabilitation Act of 1973 states in part, "No otherwise qualified individual with a disability in the United States shall, solely by reason of or his disability, be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance."
Title II defines public entity to include any state or local government and any department, agency, special purpose district, or other instrumentality of a state or states or local government. No otherwise qualified individual with a disability in the United States shall, solely by reason of her or his disability, be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. Title II defines public entity to include any state or local government and any department, agency, special purpose district, or other instrumentality of a state or states or local government. Title II was modeled closely on Section 504 of the Rehabilitation Act of 1973 and extended Section 504's prohibition against disability-based discrimination in programs and activities receiving federal financial assistance to all operations of state and local governments, whether or not they receive federal assistance. The broad reach of Section 504 is evidenced by the definition of programme or activity, which includes all of the operations of a department, agency, special purpose district, or other instrumentality of a state or of a local government, any part of which is extended federal financial assistance. Therefore, Section 504 applies to arrests and actions related thereto as they constitute operations of the police department.
The officer violated the mandate of the Supreme Court's ruling of Delaware v. Prouse by unlawfully stopping defendant. There was no reasonable suspicion that defendant was not licensed to drive without wearing a seatbelt. The officer did not have the facts required to create a reasonable suspicion that a crime was being committed. To even consider otherwise would be absurd and in direct violation of one of the things that our justice system holds sacred, our Constitution, and specifically in violation of the Supreme Court's ruling in Delaware v. Prouse. There exists no reasonable or specific basis or objective criteria to believe that the defendant was committing a crime, and therefore the stop does not conform to the mandate of Terry v. Ohio, just as in Brown v. Texas required that the officers have a reasonable suspicion, based on objective facts, that the individual is involved in criminal activity. Delaware v. Prouse. See also Lanzetta v. New Jersey. There was no basis to believe that defendant did not have the requisite license. In Lunsford v. State, court concluded, based upon the facts presented to the trial judge, we are unable to hold that the officers possessed sufficient objective facts to create a reasonable suspicion to have stopped Lunsford, and nothing more than a casual rumor. Spinelli v. United States. Credit the facts known to the Shawnee police in regard to Lunsford's suspected criminal involvement. We find that under the Fourth Amendment of the United States Constitution, they should have availed themselves to considerably less intrusive means to investigate and question Lunsford about his alleged participation in the burglary. We find that under the Fourth Amendment of the United States Constitution, they should have availed themselves to considerably less intrusive means to investigate and question Lunsford about his alleged participation in the burglaries. Without knowing if defendant has the restriction on his license or not, the officer lacks the required facts to justify the stop. The facts presented to justify the stop and eventual citation is not sufficient.
When the officer observes defendant driving without a seatbelt, he is not seeing him violating the law, because he has a license to drive without a seatbelt. Any stop where there are not sufficient facts known by the officer to warrant probable cause and justify the stop is unreasonable. A law enforcement officer may permissibly conduct an investigatory stop when he or she has a particularized and objective suspicion that criminal activity is afoot. United States v. Cortez. To meet this standard, the government must point to specific and articulable facts, which, taken together with rational inferences from those facts, reasonably suggest that criminal activity has occurred or is imminent. Terry. An officer must not act on an inchoate and unparticularized suspicion or hunch, but on the specific reasonable inferences from which he is entitled to draw from the facts in light of his experience. 27 courts determine whether a reasonable suspicion exists by looking at the totality of the circumstances and considering all of the information available to law enforcement officials at the time.
When the officer observes defendant driving without a seatbelt, he is not seeing him violating the law, because he has a license to drive without a seatbelt. Any stop where there are not sufficient facts known by the officer to warrant probable cause and justify the stop is unreasonable. A traffic stop is a seizure within the meaning of the Fourth Amendment, even though the purpose of the stop is limited and the resulting detention is quite brief. A routine traffic stop, however, is more analogous to an investigative detention than a custodial arrest. We therefore analyze such stops under the principles developed for investigative detention set forth in Terry v. Ohio. To determine the reasonableness of an investigative detention, we make a dual inquiry, asking first whether the officer's action was justified at its inception, and second whether it was reasonably related in scope to the circumstances which justified the interference in the first place. United States v. Hunnicutt.
In this case, the officer lacked the facts necessary to determine whether any law was being broken prior to making the stop. A suspicion based on such a mistaken view of the law cannot be the reasonable suspicion required for the Fourth Amendment, because the legal justification for a traffic stop must be objectively grounded. In other words, if an officer makes a routine traffic stop based on a mistake of law, the stop violates the Fourth Amendment. U.S. v. Twilley.
The officer mistakenly assumed that, since defendant was driving without a seat belt, he was breaking the law, and he made the stop, based on that mistake of law. He did not take into account the fact that defendant may not have to wear a seat belt. The exemption clause must be taken into account under the totality of circumstances. It is an important part of the law and an essential fact which must be considered. Such mistaken view of the law does not constitute the reasonable suspicion required. Legal justification for a traffic stop must be objectively grounded, and since he had no way of knowing prior to stopping defendant whether or not he had a license to not wear his seatbelt, the stop was not objectively grounded and therefore the stop violated the Fourth Amendment.
We conclude in reviewing the aggregate facts, based on the extensive findings of the District Court, that the matter totality of the circumstances cannot metamorphose these facts into reasonable suspicion. The three factors that support the agent's conclusion that defendant was evading him, the lack of eye contact, the abrupt exit and the gas station activity, become so innocent or susceptible to varying interpretations as to be innocuous. Under the totality of the circumstances, we hold the remaining factors in the aggregate do not amount to a reasonable suspicion to stop defendant United States v. De La Cruz Tapia. An objective assessment of the facts and circumstances of this stop compels the conclusion that the officer lacked any articulable, reasonable suspicion that a violation had occurred. Simply put, he saw nothing wrong, and he suspected nothing. Upholding a stop on these facts would permit the police to make a random, suspicionless stop of any car with a temporary tag. The Fourth Amendment does not afford the police such unbridled discretion. United States v. Wilson, as in the Fifth Circuit cases of Lopez Valdez and Miller, the traffic stop in the case before us was not objectively grounded in the governing law. What the officer reasonably suspected, namely the defendant had not affixed a registration sticker to his rear window, simply was not a violation of California law. This cannot justify the stop under the Fourth Amendment. United States v. Lopez Soto.
Clearly, when one applies the foregoing law to the facts, the only conclusion that can be drawn is that the officer was without a lawful basis upon which to initiate a stop of defendant. As such, any evidence obtained as a result of said illegal seizure must be suppressed pursuant to the exclusionary rule. The stop was illegal and in violation of defendant's constitutional rights as provided in the Fourth and 14th Amendments of the United States Constitution and the Constitution of the State of Oklahoma. The constitutional provision establishing the protection against unlawful search and seizure was embedded in the Constitution of our state in clear, simple and concise language. Such languages could be easily read and understood by the average layman. It says, "The right of the people to be secure in their persons, house, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, describing as particularly as may be the place to be searched and the persons or things to be seized." The Constitution of the State of Oklahoma, Article 2, Section 30. This is the exact language also to be found in the Fourth Amendment of the U.S. Constitution. The language, purpose, and intent of the provisions did not come about by virtue of a current event, but by the historical experiences of the constitutional founders and their ancestors. They were alerted to its necessity by the ruthless pillaging of their oppressors. These sections of the Bill of Rights constitute a pledge of good faith to the people of the state, all alike, that they shall be secure in their houses, papers and effects, against unreasonable search and seizures.
Based on the Constitution and case law, the stop of defendant was improper and a violation of his Fourth Amendment right to be free from unreasonable search and seizure. The Fourth Amendment to the United States Constitution governs not only traditional arrests but also seizures of the person which do not eventuate in a trip to the station house. Whenever a police officer accosts an individual and restrains his freedom to walk away, he has seized that person. To justify a particular seizure, the officer must be able to point to specific and articulable facts which, taken together with rational inferences from those facts, reasonably warrant the intrusion. The facts must be judged against an objective standard, with the facts available to the officer at the moment of seizure. Warrant a man of reasonable caution in the belief that the action taken was appropriate. Good faith or an inarticulate hunch is not enough. Terry v. Ohio, 3.
When the officer initiated the stop, defendant was seized within the meaning of the Fourth Amendment. The officer at that time had no inkling of an idea as to whether or not the person he was stopping had a license to drive without a seat belt on or not. The officer based his decision to stop defendant upon only one fact: defendant was not wearing a seat belt. The officer did not have the requisite facts to establish whether or not a crime was being committed. Treated objectively as Terry v. Ohio requires, the known facts and inferences were insufficient to warrant the conclusion that defendant was in the process of committing a crime. There must be something at least in the activities of the person being observed or in his surroundings that affirmatively suggests particular criminal activity, completed, current, or intended. Subran v. New York.
There must be something at least in the activities of the person being observed or in his surroundings that affirmatively suggests particular criminal activity, completed, current, or intended. Subran v. New York. Obviously, the actions of defendant did not suggest a particular criminal activity was completed, current, or intended. The actions of defendant are not a violation of the law. In Subran v. New York, which the United States Supreme Court found insufficient facts to justify the seizure of a person observed over an 8-hour period talking with a number of known narcotics addicts. The office lacked the crucial facts that could only be obtained after stopping defendant to ascertain whether or not defendant's actions were legal.
The initial traffic stop of defendant was unlawful as the officer lacked critical facts to even create a reasonable suspicion at the initial stop. Thus, the stop was in violation of the Fourth Amendment of the United States Constitution and Article 2 and Section 30 of the Oklahoma Constitution. The stop is in direct conflict of prevailing case law, primarily Delaware v. Prowse. Therefore, all evidence gained from the stop must be suppressed as fruit of the poisonous tree. Defendant's Fourth Amendment right to be free from illegal search and seizure was violated. Defendant was stopped by the officer by a routine stop without the officer possessing requisite facts to create a reasonable and particularized suspicion that defendant was engaged in any illegal activity. The stop amounted to nothing more than a routine stop to check defendant's papers and is illegal on its face. Therefore, any evidence gained as a result of the illegal seizure and search must be suppressed. Evidence gained illegally was the driver's license, name, address, and other information used to give defendant the citation and prosecute the case. Without such information, prosecution could not have taken place. To rule in favor of plaintiff will condone the unconstitutional acts of law enforcement to violate defendant's constitutionally protected rights any time they see him legally driving on the roads and will place a burden on him to prove his innocence over and over again each time he is stopped for doing what he has a license to do legally, which is driving without a seat belt.
Defendant's behavior was innocent activity. His conduct was not unusual. The officer did not know if defendant had in his possession the papers authorizing him to drive without a seat belt or not. Defendant made no attempt to hide, run, or avoid the officer. His actions were not furtive. The officer had no evidence whatsoever that any crime had occurred or was about to occur. Whether or not there was an offense rests on documents that defendant is required to have in the vehicle. Given that the validity of the offense rests on written documents defendant may or may not have at the time of the stop, we must view this exactly the same as the Supreme Court did in the case of Delaware v. Prowse, where the court held such stops are unreasonable and in violation of the Fourth Amendment to the United States Constitution.
Once the officer was informed that defendant had the proper papers to allow him to not wear his seatbelt, the officer had no probable cause to investigate as to whether or not defendant had proof of insurance. At that point, the officer knew that the cause of the stop was because defendant has a disability and he had no reason to believe any crime was afoot. The officer kept defendant seized and further investigated whether any crime was being committed, without any probable cause to do so, by asking defendant to provide his driver's license and insurance verification. Defendant was not breaking any laws, yet defendant was subjected to discrimination and harassment because of his disability. The Americans with Disabilities Act of 1990 states, subject to the provisions of this title, no qualified individual with a disability shall, by reason of such disability, be excluded from participation in or be denied the benefits of the services, programs, or activities of a public entity, or be subjected to discrimination by any such entity. Seatbelt stops violate the 4th and 14th Amendments. Please watch the video on YouTube called Seatbelt Stops Are Unlawful and help put a stop to these violations of constitutional rights.